Yes, no?
I didn't hear anything other than yes, no, Judge. Did you say something?
Yes, I'm going to make you the the host and then rejoin from a different computer. I'll be back.
Yes, sir. Yes, Mr. Delgado, if you can just be patient, the judge is signing on in a moment. He's having computer issues.
Oh, okay.
All right, ladies and gentlemen, I've joined from a different computer, one that the camera is out on, but I'm going to go ahead and try and call the dockets start with the Atascosa dockets. I'll ask for announcements from the attorneys. Anyone who's present who doesn't have an attorney, please let me know that you're here. In the interest of Fabian Reyna, a child.
Yes, Your Honor. Good morning, John Dist for the petitioner. We're present and ready. I think we'll need about 1 hour.
Okay, and who is on the other side?
Her name is Flor Pedrosa, and she's in the Zoom meeting.
All right, Ms. Pedrosa.
Yes, I'm here.
Okay, and are you ready to proceed, ma'am?
Yes, I am.
Okay. All right. All right, folks, give me a moment. And again, City of Jordanton versus Michael Collins.
Judge, there we go. Taxing authorities are ready. The attorney, Mr. Stephen E. Seward, he's the attorney for the IRS. He's a lien holder. I'm not sure anyone from the United States is present, but we are ready, and they were given notice of today's tax docket.
All right, so I'll just mark that with a T. We'll take the tax cases all at once. In the interest of Grace Willow Marler, a child.
There's been an agreed order, e-file, Judge. It's in your queue. Ms. Vickers called and said she has a mediation day, so she would not be able to appear.
Okay. Until further notice, being in my queue is like being in a box in Colorado. I have no access to it.
Okay.
So please email anything I need to look at to me.
Yes, sir. I'll let Norma know as well.
Is anyone here on that opposing motion to withdraw? Whose motion to withdraw is it? Anyone? Okay. Atascosa County versus Pete Olivares.
Judge, the taxing authorities are ready. Ms. Harkins is the attorney ad litem. And she was online. She did indicate to me, she's reviewed and signed everything, but she did indicate she had to go to the other docket also.
Okay. Atascosa County versus Rudy Delgado.
Taxing authorities are ready, Judge. Attorney ad litem Ireland has reviewed, signed, and filed all his required ad litem reports.
Okay. Atascosa County versus W.E. Strawn.
Judge, the taxing authorities are ready. Mr. Finkel is the attorney ad litem. I don't see him online. I've reached out to him. I'll call him again this morning and see he's going to be present.
All right, thank you. Atascosa County versus Carol Goldman.
Judge, we're going to drop this. Ms. Hawkins was appointed the ad litem to replace the other prior ad litems, and she has found some errors, so we need to review the errors. We will need to review the errors, Judge. So we're going to be dropping
Okay.
that from this document.
All right, reset on request. Tax case Juan Balderas.
Taxing authorities are ready, and Mr. Wilkerson is ready and has reviewed and signed the judgments and filed the required reports.
Okay,
And I'm present as well, Your Honor.
excellent. All right, Atascosa County versus Estela Pacheco.
Taxing authorities are ready. Mr. Finkel's ad litem. I will reach out to him.
Thank you. Another tax case, Elizabeth Thompson trustee.
Judge, taxing authorities are ready. That should be Megan Harkins as the attorney ad litem, and she has filed the required attorney ad litem reports and has signed the judgments.
All right. Atascosa County versus Susana Gutierrez.
Judge, that's a taxing authorities motion to release the excess proceeds. We are ready to proceed on that.
Atascosa County versus Maria Garcia.
Taxing authorities are ready. I will reach out to Mr. Finkel to find out his location.
Atascosa versus Alfred Godines.
Taxing authorities are ready to enter a default judgment, Judge.
In the interest of Amor Reyna, a child.
Yes, that is Flor Pedrosa's daughter. I'm here, ready to process.
Okay. All right, so we have two cause numbers, the 1512 cause number and this one.
I believe it appears so, Judge. I'll double check that.
Okay, give me just a moment. Okay, on the Wilson County docket, Mark Mendez versus Guadalupe Valley Electric.
Your Honor, Roger McCleary, representing defendant Hubble Power Systems, Inc. We have a motion for summary judgment pending. We're ready.
Plaintiffs here and ready as well, Your Honor.
Your Honor, James Ramsey for defendant Guadalupe Valley Electric Cooperative. I'm here as well.
All right. How long to hear this?
I would say 45 minutes to an hour.
Agree.
All right, I'll mark you 60 minutes.
Thank you, Your Honor.
Matter of the marriage of Alec and Caitlin Lerma.
Case has been dropped, Judge, and reset on request.
In the interest of Austin James Tucker, a child.
His parents are here. His father and his stepmother are both here, and the child is here.
Okay, and this is an adoption?
Yes, sir.
And have you all done the paperwork all yourselves?
Yeah, we had a company do the paperwork for us, and we filed on our own. There's no contest. His birth mother passed away over 5 years ago, and he has been living with his natural father since then. And
Okay.
me.
All right. Give me just a moment. In Ray AB Juskina Family Trust.
Carol Birch for petitioners, Your Honor. We're ready and we'll take about 15 minutes.
Okay, and what do we have to hear?
It's just a modification of an irrevocable trust.
All right. Anyone else told to be here today?
For the Juskinia matter, you mean?
For any dockets? Okay, I'll let the attorneys who need to confer. I will make Ms. Riley the host so that she can handle the breakout rooms again. Ask her to make me the co-host. And I'm going to ask the parties in the Amor Reyna case to confer. We have all the tax cases where you're waiting on Mr. Finkel. On the Mark
Judge.
Mendez versus Guadalupe Valley Electrical Co-op, I'm going to ask the parties to email to the coordinator any documents that I may need to look at. So I guess that makes the adoption first up. Let me look at that. Give me a moment to pull the file.
If anybody else needs a breakout room, please let me know.
Your Honor, with respect to the documents in the Mendez case, does that include the actual motion or just specific exhibits for the presentation?
Whatever you think I need to be able to look at.
Thank you, Your Honor. Will do.
Fabian Reyna, Flor Pedroza, and John Disra. I have assigned you a breakout room 1 if you'll accept that, please.
And Judge, this is Ronald Rocha. I have an update on Mr. Finkel when you're ready.
Go ahead, sir.
He emailed me that he is not ready and he would like a reset. These cases have been, all of his cases have been reset previously, at least 2 or 3 times already.
If you'll get me a list of them, I will remove him and appoint someone else.
Thank you, Judge. And we're ready when you are.
All right, we're gonna do the adoption first, it looks like. All right, Mr. Hott, I'm going to ask you to bring the Tuckers in.
Judge, are they here in our building? Is that what you're saying?
I thought I was told that, yes.
No, they're on the Zoom.
Oh, okay. Oh, I see. I thought they said they were in the building. All right, Mr. and Ms. Tucker, one, do you have your proposed decree or order for the adoption?
We have the paperwork in front of us, and we've turned in all the paperwork to the county back in February.
Okay, did you turn in a copy of your proposed order
Yes,
for
sir.
the adoption? Hold on, let me see what this is. Thought it was just birth certificates. Yeah, no, this is not the order.
We turned in the order back in on.
Okay,
June.
I'll ask you to take that up with the district clerk's office. Ms. Tejada?
Judge, that's all I saw in the file, and it was not noted in the system that the order was in there either.
I have where I turned in all the paperwork on February
Hey, man,
6th.
you turned in a bunch of paperwork. Did you turn in the order that orders the adoption?
As far as I know, yes, sir. I mean, I turned in the order, all the paperwork that said order granting adoption, things like that.
Now, and Mr. Tucker, I'm going to ask you to remove your hat while you're in court. Now, you have a motion here asking me, because it's a step-parent adoption, to waive the social study
Yes, sir.
investigation, okay?
Yes, sir.
And it says you'll still have to complete the background check with the fingerprints. Have you completed that and turned that in?
My fingerprints are on file with Bear County. I have a CHL license, and so they're on file already.
So that's a no. Ms. Tucker?
Yes.
Okay. Ma'am, I mean, I have a CHL myself. I know that it acts in lieu of a background check for something like purchasing a new firearm. If you have your current CHL, you don't have to just present that. You don't have to go through the background check to present a new firearm. I am not aware that the adoption statute, legislature changes stuff all the time, but I'm not aware that the adoption statute says that if you have a CHL, you do not have to go through a background check on an adoption.
Okay.
So what I'm going to ask you to do is to get that filed with the Department of Public Safety, get the results filed here, and get your proposed order on the adoption.
I apologize. I don't know what other paperwork to turn in.
Okay, well, ma'am, there is no order of adoption, whether it's called a decree of adoption, final order, final decree. That is not in the file. I don't know if you turned it in or not. I can tell you it's not in the file, so you're going to have to get that to the district clerk's office, plus the results of the plus have to do the background check with the DPS.
Okay, I guess I'll check with the county and see what happened, because I did turn that in on February 12th.
Okay. I'm holding up the file folder. Of course, the camera on this computer doesn't work, so you can't see it. I have the file folder in my hand. It's not in the file. I would expect everything got in the file because we have the birth certificates, we have the application, we have marriage certificate, we have your proposed certificate of adoption. We have everything except that. So I don't know if that was turned in or not, but it's not checking with the district clerk's office. You're going to have to get them a copy of it.
Okay, and that was again the proposed order of adoption that is
Yes.
missing?
Yes.
Okay,
All right. And just get with the coordinator's office, get this set. Whenever you have all of that.
okay, thank you.
I mean, you can get the order. You can just scan that and email it to them or take it to them. If it was just that, I'd say just scan it or drive it over here and we do it this morning. But we need to have the DPS background check too. And again, if there's something that I don't know about, if the family code's been modified to say CHL is good enough for the background check for adoption as well as for purchase of firearm, that's fine. But I'm not aware of that. And if it is, I would go ahead and hear this whenever we get the order in.
Okay, thank you.
You're welcome. Okay, are we ready in all the tax cases that do not involve Mr. Finkel?
We're ready, Judge.
Okay. All right. And is Mr. Kate here too, or just you?
Mr. Kate went ahead and signed off, but he's in agreement to replace Mr. Finkel. The case he did have included Mr. Finkel.
Okay. All right, then I will call all the tax cases that were not reset, that do not involve Mr. Finkel, and order that they be consolidated for trial. Go ahead, sir.
Judge. Also, please take judicial notice of the court's file of all parties that were served today. We sent out notice of today's Zoom hearing to all parties who filed answers and to also those who are to be in default. I also like to include the attorney alignment fees for those individuals for their statement of evidence and their due diligence to locate the known or unknown heirs of $495.
Yes, I'll so order that. And I will admit without objection all of your tax statements and exhibits into evidence.
Thank you, Judge. If you allow us to proceed to foreclosure against these properties for the delinquent taxes that are currently due, if the taxpayer has a current payment contract with the taxing authorities or files any type of deferment with the appraisal district that defers the taxes, we will not proceed to take a tax suit to sale. And allow us to do that, Judge, please.
I will.
There's only one other motion, Judge, that we have on today's docket that was not part of a judgment. That was suit number 1905-0499 CVA. It's the Atascosa County et al. Versus Susana Gutierrez et al. It's the tax authority's petition for excess proceeds.
Okay.
This is a property that was set for tax sale. There was over $11,000 in excess proceeds in the court's registry. The district clerk sent out the required notice under chapter 34.01 of the tax code. The defendant was still liable on January 1st for the 2019 taxes. So we're requesting under the tax code, chapter 34, under 3401, that the amount of $1,754 paid towards the 2019 taxes and the remaining excess proceeds stay in the court registry until either the lien holders or the owner comes forward with a motion order to take out the rest of the remaining monies, Judge.
Okay, I will order that also.
Thank you, Judge. And then we will forward the motion, the orders for the replacement on the other three for the attorney items also.
Okay, and take your time because I'm having computer issues. They've ordered a new one for me. And I found out that the camera is out on my personal laptop because I never use it except for when I do Zoom. So I'm having issues right now. But so with that, you are excused. Thank you.
Thank you, Judge.
Okay, and where do we stand in the GBEC case?
Your Honor, we submitted our response, we being the plaintiff, submitted our responses and proposed order to Ms. Riley, and we're ready to proceed. And as well.
Your Honor, I have at least attempted to email the documents to the coordinator into your office, so they may be in transit.
Okay, and this
Who's
is,
that from? Because I've gotten 2 emails on the case. One from a Rosa, well, they're both from Rosa Tovar Salmon.
That's from the plaintiff, Ms. Riley.
Okay.
okay, well, as long as it's on the way, and let me see. The Justina case looks like it would be short also. Let me pull that file and then we'll call that.
Judge, you want me to send that these emails directly to your judge email account or okay.
And Your Honor, my email was directed to coordinator@81-218.texascourts.gov. I'm assuming that's the correct email address.
Is that
Yes,
from
that will
McCleary?
work.
McCleary, is that correct?
Yes, Roger McCleary.
I got it. I'll forward over as well.
Thank you. Appreciate that.
Yes, sir. So you should have 3 emails from me, Judge.
All right, Ms. Bursch, go ahead.
Your Honor, this is an irrevocable trust established by the parents, Mr. and Mrs. Jaskinia, to hold some mineral interests for their children and for their benefit. Mr. Jaskinia has died, but Mrs. Jaskinia unfortunately has dementia and requires nursing home care. She doesn't have enough money to pay for her nursing home, so we're trying to apply for Medicaid to assist her in doing that. The interest that she has in the irrevocable trust prevents her from qualifying for Medicaid. So our goal is to modify the trust to allow the trustees to distribute her interest to her outright. She can then sell it and then spend the money on her nursing home care and then qualify for Medicaid. So the trustees, the 3 trustees are seeking permission to modify the trust to allow them to distribute her share, Mrs. Jaskinia's share, to her outright.
Okay, and the trustees are also the alternate beneficiaries or additional beneficiaries?
They are additional beneficiaries. All of the children are beneficiaries and the trustees are 3 of those children.
And are there any children who need to be notified of this, who have not signed off on this?
All the children were notified, but we did not get their waivers. We certainly can. None of the children object because it doesn't affect them.
Okay,
It doesn't affect their interests.
okay, that's fine then. I won't go any further than to say I never assumed that somebody wouldn't object to, mother not being thrown out in the street and starving. You'd be surprised, or perhaps not. All right, I will sign off on your proposed order.
Thank you, Your Honor.
You're welcome.
May I be
You are
excused?
Yes, ma'am.
Thank you.
Okay, I'm going to read over these documents. I need to do a couple of other things. Let's take a break until 10:15, and we'll come back at 10:15 and get started.
Thank you, Your Honor.
Actually, I have the plaintiff's reply, the movant's response to that reply, and some objection documents, but I do not have the actual motion.
Your Honor, I could try to send it again. That should have been in the email I sent earlier. Let me try to send it once more.
All right, thank you.
Thank you.
Okay, I'm back. All right, I have read through the motion and the response. This is just one of those days. Give me just a moment.
Yes, Your Honor.
Okay, now I have a pen that's not run out of ink. Okay, I've read through the motion and the response. I will let both sides argue this however they want, but looking at it, it looks to me that there's no doubt the statute of repose applies. I think there's ample evidence, more than enough to show that the piece of the splice was sold more than 15 years before the lawsuit was commenced. But when it says it's a permanent solution, I don't know that the Civil Practice and Remedies Code talks about if it's warranted for a particular number of years, but I don't know that stops a manufacturer from warranting it forever if it says it's a permanent solution. So that's the thing I would mainly be interested in, but you could, again, go ahead and argue whatever you need to.
Thank you, Your Honor. Your Honor, first for the record, this is Roger McCleary. I represent defendant Hubble Power Systems movement in the case. And my understanding is that we do have a record of the hearing. So I just wanted to confirm that. Is that correct?
Yes, Ms. Cavazos is nodding. She is there.
Okay. And hopefully, I'm trying to share my screen. I don't know if the court can see.
Yes.
What I have up. All right, thank you. I will move quickly through these. The court obviously has a handle on the motion. The bottom line is the plaintiff seeks to hold Hubble responsible for a splice that was actually manufactured in July of 1994 and sold, according to the exhibits we offered, more than 22 years prior to August 7th, 2019, which is the date the suit was filed by plaintiff or commenced by plaintiff against Hubble Power Systems. Of course, we claim that all of plaintiff's claims and causes of action are barred under the 15-year statute of section 16.012 et sec, which, as the court is aware, applies to all product liability claims, which are what are asserted against Hubble in this case. Getting to the specific terms of the statute, Your Honor, 16.012b requires that a claimant commence a products liability action against a manufacturer or seller before the end of 15 years after the date of sale of the product by the defendant. In this case, the plaintiffs have asserted an exception. They have the burden to prove the exception to application of 16.012b. They have the burden to establish that Hubble, or its predecessor actually in this instance, Fargo Manufacturing Company, which actually manufactured and sold the splice, that Fargo expressly warranted in writing the product had a useful safe life of longer than 15 years, and they must file suit before the end of the number of years warranted. The plain terms, language, and meaning of the statute requires that there must be an express warranty, Your Honor, with a stated number of years. There's no evidence of that in this case. Briefly on the background, accident happened August 11th, 2017. The plaintiff was shocked, attempting to cross over a cattle fence. When the lawsuit was filed originally on June 12th of 2019, the plaintiff sued GVEC, Guadalupe Valley Electric Cooperative. They were the only defendant then, and they are still a defendant in the case. So even if the summary judgment is granted as to Hubble Power Systems, plaintiff still has plaintiff's claims against Guadalupe Valley. It wasn't until plaintiff filed their first amended petition on August 7th, 2019, that they commenced their products liability action against Hubble Power Systems. And again, that was over 22 years after the evidence indicates and establishes as a matter of law the splice had been sold by, and over 25 years after the splice had been manufactured by Fargo. Plaintiff's petition alleges the power line fell over the fence and broke, and they seek to hold us liable for the splice sold by our predecessor, Fargo. The particular splice at issue, Your Honor, is a Fargo GL402 splice. That's the catalog number, GL402. Again, manufactured by Fargo, the predecessor and interest of Hubble. And we have provided the court as Exhibit A to the summary judgment I'm pulling up here. Hopefully the court can see this. Your Honor, this is the declaration of Mr. John Egan. Exhibit
No,
A.
I'm still seeing just a list of your emails, it looks like.
Okay, well, that's it. All right, do you see it now?
Yes.
Okay. I may be showing a different screen than I thought. Very briefly, Your Honor, this is the declaration of John Egan, and attached to it, Mr. Egan is an associate engineer for Hubble at this time. Attached to it are images of the remnants of the splice that were taken from an inspection in March of, as I recall, 2020 regarding the splice. And so the court, I might have this zoomed out a little too much, but the splice is cut up here, and Exhibit 2A2 is another shot of the splice in addition to A1, which I just showed you. And the point is, as I scroll down on these images, we get to A4, which shows the end of the splice, which shows it's manufactured by Fargo. It shows the catalog number, and it also shows, as we zoom in on exhibits A5 and A6, the manufacture date. And right here between the fingers to the left of the, looks like a red number 9, you can see stamped in this photo 794. And so that confirms this was manufactured by Fargo in July of 1994. And Exhibit A7 is a magnified version showing that. The plaintiff, as the court gleaned from looking at the pleadings, contends that there's a fact issue on the date of sale. The court has recognized that there's strong, in fact, uncontroverted evidence that the sale was no later than May of 1997. And the plaintiff, of course, objects to the affidavit of the declaration of Mr. Jack Myers on this point. They contend the thrust of that affidavit is that it's virtually certain the splice was sold. And in fact, Mr. Myers' declaration clearly states that it was sold by his departure from the company in May of 1997. They also object to the splice on the grounds they claim it wasn't based on personal knowledge. They claim he can't be certain of the date it was manufactured. No invoices or documents or purchase orders or receipts exist or have been offered that establish when the splice was sold, and that there was no evidence or proof produced which actually shows when the splice was sold. Of course, we disagree with that. Clearly, the declaration of Mr. Myers is right on point and establishes it was sold prior to May of 1997. And then, of course, plaintiff relies on this exception to the statute of repose if they can prove an express warranty of greater than 15 years based on a stated number of years. Your Honor, I don't want to belabor the court, given your statements earlier. I did just want to point out with respect to the affidavit of Mr. Myers, or the declaration, I should say, attached as Exhibit B to our motion. Can the court see this?
Yes.
Thank you. It's a declaration of Mr. Jack Myers. Mr. Myers was with the company over 27 years with Fargo. The declaration, the first paragraph confirms he has personal knowledge of the facts stated in the declaration, and the facts are made based on his personal knowledge unless expressly stated otherwise. He goes on to describe his history, extensive history with Fargo Manufacturing as an area manager in 1969, promoted to marketing manager, working out of Fargo's headquarters and their manufacturing facility in Poughkeepsie, New York. In '76, he became Fargo's director of sales and marketing, and he was promoted to Fargo's vice president of sales and marketing in 1985, a position that he held until he left his employment at that Poughkeepsie facility in May of 1997. He points out that from the time he became the marketing manager in 1974 until May of 1997, he was based out of and worked at the Poughkeepsie facility. All of Fargo's manufacturing operations for GO402 splices were located at that facility. And the splices manufactured by Fargo were stocked by Fargo unless Fargo had no remaining inventory of 402 splices, all at the Poughkeepsie facility prior to sale. The sales of Fargo's splices, GO402 splices, were supervised and managed out of that Poughkeepsie facility. He describes his job responsibilities as the vice president of sales and marketing, including overall responsibility for the sale of all Fargo products, including the GO402 splices, and that he was generally familiar with Fargo's operations at the facility and Fargo's products, including the GO402 splices. He also declares that throughout his employment, he monitored and familiarized himself on an ongoing and then current, virtually daily work basis, the sales and numbers and stock inventories of Fargo's products, including GO402 splices, and that he was familiar with Fargo's stamp protocol to identify the splices. He goes on in the next paragraph, just in summary, to review the photographs that we reviewed that were attached to Mr. Egan's declaration, attached as Exhibit A, and he confirmed the splices based on those photos, that the splices, Fargo splice manufactured by Fargo, GO402 splice that was manufactured out of the Poughkeepsie facility, that had a date code of 794, that confirmed it was manufactured in July of 1994, over 25 years before Hubbell was sued in this lawsuit. Mr. Myers goes on to describe how in paragraph 4 of his declaration, how GO402 splices were hot-selling, high-velocity products for Fargo throughout most, if not all, of the time period from January of 1994 through the end of his employment in May of 1997, which we refer to as the 1994 to 1997 sales period in Mr. Myers' declaration. He goes on to describe their goals at Fargo to keep 1 month of inventory of GO402 splices in stock, but that generally during that period of time, the GO402 splices were generally all sold and shipped by Fargo to Fargo's buyer customers within 1 to 2 weeks of the dates they were manufactured. That was in policy and practice, they were sold, these splices, on a first manufactured, first sold and shipped basis. And that the splices were generally sold then within those 1 to 2 weeks, if not virtually immediately after they were manufactured. And he goes on to very clearly state that in any event, it is virtually certain that all GO402 splices manufactured by Fargo during that 1994 to 1997 sales period were sold and shipped by Fargo to Fargo's buyers and customers within 2 months of the dates the splices were manufactured. He goes on to offer his clear and definite recollection that on many occasions during the 1994 to 97 sales period, including after the splice was manufactured in July of 1994, the entire inventory of Fargo splices were sold and shipped by Fargo to Fargo's customers. Fargo had no inventory of GL402 splices in stock. Fargo's manufacturing operations ran on a 24-hour basis to manufacture these GL402 splices for virtually immediate sale and shipment to Fargo's buyers' customers. And he just points out that he recalls that in particular because during that period, that was near the end of his approximately 28 years of employment with Fargo. So in paragraph 5 of his declaration, he confirms, based on his personal knowledge, that it is virtually certain the splice was sold and shipped by Fargo to Fargo's buyer customer by approximately October 1, 1994. And that's what plaintiffs focus on in their response. That language, they ignore that he goes on to say, and the subject splice was certainly sold and shipped by Fargo to Fargo's buyer customer long before the end of his employment at Poughkeepsie facility in May of 1997. He says, based on his personal knowledge, there is absolutely no possibility the subject splice was not sold and shipped by Fargo to Fargo's buyer customer prior to the end of his employment at the Poughkeepsie facility in May of 1997. And then he goes on to address the issue the court raised with respect to warranties. Again, the statute exception requires that for there to be an exception, there must be an express warranty of a stated number of years greater than 15 years. In Mr. Meyer's declaration, he says during his employment, he was generally familiar with Fargo's warranty program for GL402 splices, and it was Fargo's longstanding practice before and during that sales period to only extend a limited warranty of 1 year with respect to GL402 splices. And he didn't have a copy of Fargo's warranty during the 1994-1997 sales period. And this gets into the public policy reasons, of course, behind this statute of repose, because documents are no longer available from that far back, and that's the case here. He says he had read the Hubble warranty that's dated 2009, and it's attached as Exhibit B1 to Mr. Meyer's declaration, and it's attached as Exhibit C1 to Mr. Jenkins' declaration, which identifies and proves that document up as a business record. And he goes on to describe that based on his personal history with Fargo, his personal familiarity with Fargo's written warranty policies and practices during the course of his employment as Fargo's VP of Sales and Marketing, and also to the best of his personal knowledge, information, and belief. Fargo would not have warranted in writing and did not warrant in writing at any time that GL402 splices sold during the 1994 to 1997 sales period, including the subject splice, the particular splice at issue, had a useful safe life of longer than 15 years, and Fargo did not do so in any use or reference to the term permanent in Fargo's catalogs, technical bulletins, or other marketing literature or materials regarding the splices. And it's obviously Mr. Meyer's declaration is a focal point of the arguments in the case and of plaintiff's objections, so I thought it was important to review that in some detail. Your Honor, the plaintiffs do challenge it on the basis that it's not an affidavit, but as the court's aware, under the Civil Practices and Remedies Code, Section 132.001, and associated case law, an unsworn declaration may be used in lieu of a sworn declaration or affidavit. With respect to the date of sale, Your Honor, we've cited the Bustamante case and other authority, which stand for the proposition that you don't have to identify and provide evidence of the specific actual sale date. If you can provide evidence of the circumstances that demonstrate a date by which the product would have been sold, which is exactly what we have here through Mr. Meyer's declaration. And I won't belabor the court with going into that unless the court wants more information about that case.
Oh, go ahead.
Okay. And Also, it doesn't matter who the product was sold to. All you have to show is the first date of sale of the product. And we cited the Dolphrey versus Boss Hoss Cycles Inc. and other cases to that effect. And that's 456 F APPX 329 at 333. So we've also cited authority, Your Honor, for the proposition that it is plaintiff's burden to establish the 16.012C exception to the application of 16.01B. We cited the Pawitsky case, Kofer case, the Garza case, and those are all referenced in our response. With respect to the permanent terms, the plaintiff offers a number of exhibits, Your Honor, that refer to the term or use the term permanent. There are documents, there's a transcript of a video. Plaintiff has not demonstrated, and we've objected to plaintiff's evidence. First of all, plaintiff hasn't demonstrated any of it is relevant to a splice that was sold by Fargo prior to May of 1997. A bunch of documents from Hubble or statements by Hubble or a video by Hubble. The video was put online in 2014 or 2015, has no relevance or bearing to what a splice sold in by May of 1997. And again, the plain language of the statute requires that the plaintiff demonstrate a warranty with a number of years warranted. There's no evidence from plaintiff of any alleged warranty for a number of years. In fact, the only evidence of a written warranty for a number of years is Mr. Meyer's testimony that, at least with respect to from Fargo, is Mr. Meyer's testimony that they never warranted anything for more than 1 year. Plaintiff relies on in support of their argument about that they only have to show a representation of more than 15 years. They rely on the White versus Cone Blanchard case. Your Honor, that case is completely inapplicable. It is a 2002 Beaumont case regarding a 1997 accident. And in that place, first of all, I should point out that a different statute of repose was at issue in that case, not the one in effect, and that is the subject of our motion. In the White case, the CBC Cone Blanchard Corp defendant hadn't manufactured the grinding machine at issue. They had purchased some assets from the manufacturer, which was CBMC. They claimed that the plaintiff had sued the wrong party and that they were not a successor to the manufacturer. And they also asserted the statute of repose, section 16.012. Main issues in that case were choice of law, successor liability, and whether Vermont law applied where the manufacturer was organized, or whether Texas law applied where the action occurred. And the court found Vermont law applied, there was no successor liability. And even if they had found successor liability, that 16.0 would bar the claim. And in that case, there was no evidence of any warranty representation or anything. The court said that the defendant was unaware, should be CNBC, was unaware of any evidence that CBMC made representations back in 1981 the machine had a useful life of more than 15 years. Plaintiff has not brought forward any evidence which would contradict those statements. So they didn't even have to analyze the statute that applied back then, much less analyze and apply the current statute. The old statute simply, Your Honor, provided that if a manufacturer, does the court, are you able to see this PowerPoint, Your Honor?
Yes.
Okay. That old statute provided that if a manufacturer or seller expressly represented the manufacturing equipment had a useful life of longer than 15 years, et cetera, then there would be exception. The language is, the full language is included. However, the act was amended in September 2003 for the legislature requiring not just a representation, but that the manufacturer or seller expressly warrants in writing the product has a useful, safe life of longer than 15 years. And a plaintiff must commence the product liability action against that manufacturer seller before the end of the number of years warranted. The number of years is specifically stated again in the statute. So in the White case, there was no evidence of anything whatsoever claiming a safe, useful life of longer than 15 years. Plaintiff didn't have to consider the statute. There was no analysis of whether there was a written warranty of a sale or of a safe, useful life for a number of years longer than 15 years. So it offers no support for plaintiff's arguments. And it's just contrary to the express language of the current statute 16.012C. Your Honor, we have also offered exhibit testimony, deposition testimony from witnesses who are corporate representatives of GVEC. One of them was Mr. Sean Alvarez, and that's attached as Exhibit G to the declaration. Can the court see this excerpt I've pulled up?
Yes.
Thank you. And on page 90, line 8, Mr. Alvarez was asked, so my question to you, sir, is, as a company representative for GVC, would it be fair to say you are not aware of any written warranty extended by or from Fargo Manufacturing Company relating to the splice at issue in this case, the subject splice, as it's been referred to, other than the substantive 1-year warranty, as far as you know? And Your Honor, we described in the earlier excerpts that are provided to the court in this exhibit that the substantive 1-year warranty is the substance of the exhibit to Mr. Myers' declaration and Mr. Jenkins' declaration, except as substituting the name Fargo Manufacturing Company or Fargo in place of Hubbell Power Systems or HPS. So he's referring to that 1-year substantive warranty as identified earlier in the deposition. And he says, as far as I know, we haven't been able to locate any other documentation that would say otherwise. In other words, they haven't located anything suggesting there was anything other than the substantive 1-year warranty, if there was that. And we go on, because his answer is, quote, on page or line 16, as far as I know, we have not been able to locate any other document that would say otherwise. Continue on page, on line 19. All right, and you're not aware of any warranty ever issued by Fargo that would extend to GVEC with respect to Fargo's products or a Fargo product, other than the one that would be a 1-year limited warranty consisted with the substantive 1-year warranty. Would that be a fair statement as you see here today? On page 91, he answers line 1, answer correct. That would be a fair statement. We were not able to locate anything that would say otherwise. Response, thank you, sir, ending on page 91, line 4. We also have included, Your Honor, deposition testimony from GVC company representative Bobby Christmas. And briefly, although there are more excerpts we submitted, on page 235 of that excerpt in Exhibit H to our summary judgment motion, he was asked questions about what they've been able to locate in response to document requests. On line 6 of page 235, I'm sorry, line 7. And certainly you never located, and GVC has never located any written warranties or any other written documents with warranties or representations regarding the subject splice. You weren't able to find any such documents, correct? Answer, we were unable to locate. Yes, sir. Question, all right. And similarly, to the extent that there would have been any documents from Hubbell, if any, that related to specifically the subject splice, you've not been able to locate, and that you have not produced any, either you or GVC, to your knowledge, as GVC's corporate representative, correct? Answer, that is correct. And so you have no knowledge or information about what information or documentation or communications anyone involved in the decision to purchase that subject splice had or used or relied upon in making the decision to purchase the subject splice? Answer, correct. And on page 236, that was through 236 line 2 on 236 line 3. Question, and certainly GVC has no information suggesting anyone involved in the purchase of the splice for GVC have reviewed any video, or for that matter, any other documents from Fargo or from Hubble regarding the subject splice before the decision was made to purchase it. Fair statement? Can you repeat that question? I will try to. It was a little long. Question, you have no knowledge of GVC or anyone involved in the purchase of the subject splice for GVC having reviewed any video or other documents directly or indirectly from Hubble or from Fargo or Hubble concerning the subject splice or other GEL 402 splices prior to the decision to purchase the subject splice as you sit here today, correct? Answer, correct. And that's ending on page 236, line 20. Your Honor, we've cited authority, the Texas Health Presbyterian case 569 Southwest 3rd 126. Statutes are to be construed by applying their common ordinary meaning of their words. Unless the text supplies a different meaning or common meaning leads to absurd results. Here, the plain language of the text requires the plaintiff establish an express warranty with a number of years greater than 15 years. And we've cited authority also under the Texas Business and Commerce Code, section 2.313A, and the Sears case and the PBG Industries cases, that an express warranty arises from an affirmation of fact or promise made by the seller to the buyer, which relates to the goods and becomes a part of the basis of the bargain. In other words, before any extra contractual statement becomes a warranty, it must become part of the basis of the bargain. A statement cannot be a basis of the bargain if one of the parties doesn't know about it. So, Your Honor, in sum, the plaintiff has not and cannot meet their burden to show the exception under 16.012C applies. There's no evidence of a written express warranty that of a safe, useful life or a number of years longer than 15 years with a specific number of years that was provided in regard to this particular splice.
Okay. All right. And for the, go ahead, sir.
I just, in wrapping up, Your Honor, we cite some public policy cases, and just very briefly on this, that address the key purpose of the statute of repose being to eliminate uncertainties under a related statute of limitations and to create a final deadline for filing suit that is not subject to any exceptions, except any clear exceptions in the statute itself. Without a statute of repose, actors would face a never-ending uncertainty as to liability for their work. Statutes of repose take away the rights to enforce a right. They create a substantive right, be free of liability after a specified time. And the purpose is to provide absolute protection to certain parties from the burden of indefinite potential liability. Additionally, a practical upside of statutes of repose and curbing open-ended exposure, which plaintiff is trying to impose here with respect to their arguments on permanence, is that it prevents defendants from answering claims where evidence may prove elusive due to unavailable witnesses, perhaps deceased, faded memories, lost or destroyed records, and institutions that no longer exist. We have those circumstances here, Your Honor, with respect to no sales documents from back in the mid-90s. And Fargo is no longer operating as Fargo Manufacturing, Inc. Your Honor, we've asserted objections to the evidence and proof, again, offered by the plaintiff. I know the court can consider those later anytime the court wants. But again, I point out that the plaintiff hasn't demonstrated that evidence and proof is relevant to demonstrate an express warranty for a stated number of years of a safe, useful life with respect to this splice manufactured in July of 1994 and sold by May of 1997. So they have not met their burden, and the motion should be granted, Your Honor. I'll be happy to answer any questions, and otherwise I'll certainly let Ms. Roziers respond.
Okay, I don't have any questions right now. I ask you to stop your sharing. Go ahead, ma'am.
Yes, Your Honor.
Actually, Your Honor, Judge
Oh,
Wilson.
the other plaintiff has something, other defendant?
No, sir, this is Frank Gatta. I'm going to argue on behalf of our plaintiffs. I am a co-counsel.
All right, go ahead, sir.
So, Judge, what I'll do based on the guidance you gave us early on about your view of the declaration of Jack Myers, I'll do a technical point first. Then I'll give you just a tad bit of color. And finally, I'll argue why it is that we believe that the exception created by the statute of repose is exactly what's applicable here. So first, with regard to the technical point, so we do believe that the declaration of Jack Myers, somebody who hasn't been with the company for over 24 years, does not meet the level of personal knowledge required by all of the law stated in our particular response. Virtually certain is not enough to meet the requisite burden. He wasn't a custodian of records. He didn't look at any documents. In fact, most of his affidavit or declaration is based on another person's affidavit. We understand the way Your Honor sees it. So to the extent we have an objection, Your Honor, may I please have a ruling of overruling my objection on the record?
I'll overrule your objections to the affidavit.
Thank you, Your Honor. Now color.
So statement, was it affidavit or a statement? Written statement?
Declaration of Jack F. Myers.
Declaration. Right. All right, go ahead, sir.
All right, so Judge, so a little bit of color. So originally we just sued GVEC because for some reason this splice failed. There was two other splices right next to it. It touched a fence. Our client, Mr. Mendez, the chief of the volunteer fire department, was trying to go through the fence, nowhere near where this line failure was, and he ends up getting electrocuted and having a very severe injury event. But GVEC then said, hey, these guys over here are Hubble, they're a responsible third party. So we added them to make sure that we understood why they were saying that. And in the course of taking these depositions, a couple of things became apparent. One is we kept asking all these good GVEC folks, hey, when do you replace these splices? How do you figure out when something has been there too long and you need to do something about it? And to a T, Judge, each of them said, really? We just kind of look at them as we're driving around, and when they fail, we replace them, which is extremely odd to me when you're dealing with electricity and things that can kill people and hurt them very severely. So then we started asking them about what they believed about these splices, and this training video came up. And so the context of it was they said, look, we believe those splices are there forever. That's why we wait till they fail. And in fact, there's a training video that's on Hubble's site today that talks about that even today. These are permanent solutions to these problems. Now, that's important for a couple of reasons. One is these folks are still trying to decide policy. When do we replace these and when do we not? And yet they're being told by the manufacturer of the product to this day that these are permanent fixes. You don't have to do anything about it. That's number one. Number two is that it goes into the secondary part. As we start asking for documents for Hubble and we start looking at everything that they produced, and this word permanent came up, we realized why it is that the GVEC folks believe this is an actual fix that does not need any work after the fact. And that's kind of what my response is going to be about. But let me start with something that is important, Judge. I keep hearing Mr. McCleary say it's their burden to prove that the exception exists. And I agree that that's our burden in front of a jury at the time of trial, but that is not our burden today. This is a motion for summary judgment, and you've been given a whole lot of evidence to consider, okay? And just to give Your Honor the context of this evidence, it's crystal clear that all we have to show is that there's a genuine issue of material fact, whether or not the statute of repose applies. That's Montgomery versus Cnty, 669, Southwest 2nd, 309. But this is important. In deciding this motion, Judge, all of the evidence that you're going to see under the Nixon versus Mr. Property case, 690, Southwest 2nd, 546, every single part of the evidence must be taken as true, and every reasonable inference must be indulged in favor of Mr. Mendez. So look, I'm going to tell you, Judge, there's a lot of things Mr. McCleary and I see differently. We've been doing product liability law for a long time. I was here before the statute changed. And let me tell you what the biggest issue that we have that's different. If I may share my screen, Your Honor.
Yes, go ahead.
First of all, and just for the record, Your Honor, we have attached exhibits A through M to our response, and we ask that Your Honor, we incorporate those into our response, that Your Honor take judicial notice of them, subject to Mr. McCleary's objections.
Your Honor, we have objected to those exhibits. The objections are filed in writing.
Okay, we'll go through the objections after Scara finishes his argument.
May I proceed, Your Honor?
Yes, sir.
So I think a very fundamental difference, Your Honor, that exists between the way I see the statute and the way Mr. McCleary sees the statute is how he uses the word breach of warranty. In other words, a cause of action in one part, or warranty, a noun in another part, a noun, or actually the word warrant, which is the word used in the statute. So it's important because if you look at the way the statute is written, can you see this okay, Your Honor?
Yes.
I'll try and make it so we can read it. But this is the statute. It talks about claimants, but then it talks about product liability actions. And it talks about means any action against a manufacturer or seller or recovery of damages or other relief by a defective product, whether the action is based in, and this is important, strict tort liability, strict products liability, negligence, misrepresentation, implied warranty, and actually it's, if I go back over here, let me see if I can make it work. Right before this word implied warranty is breach of express or implied warranty or any other theory. Now, why is that important, Judge? So our cause of action against Hubble in this case is based on strict product liability. Our theory is that they failed to warn the GVEC folks how to properly tension the splice once it was on the line, number one. And number two, how to use what size of line with which kind of splice. And in fact, GVEC is going to tell you that that's exactly why it is that they brought them in. But one of our causes of action that we don't have in this case is we have not claimed a breach of express or implied warranty against Hubble. And the importance of that, Judge, is that every single case that they gave you, which has to do with this word reliance, in other words, is reliance any part of the statute? All of those cases were breach of express or implied warranty cases in which reliance is an element of recovery. That is not our case. Reliance is not a part of our recovery based on strict tort liability or based on our negligence case. So all of this statute right here, the only reason that we're using it is not for a cause of action, but only if Your Honor finds there's a fact issue with regard to the exception, that extends the statute of repose, but not because it's a cause of action. So now let's go down and talk about where we have a difference in words. So you'll see that the part that Mr. McCleary keeps talking about, let me find it, C. Okay, so the exception is C. If a manufacturer or seller expressly warrants in writing, warrants the verb, okay? And warrants the verb, Your Honor, means to declare or to assure, okay? It does, and say, so if a manufacturer or seller expressly warrants the verb in writing that the product has a useful safe life of longer than 15 years, a claimant must commence an action, products liability action against the manufacturer or seller of the product before the end of the number of years warranted after the date of sale by the product of the seller. So what's important about that? I agree with Mr. McCleary. It's important to look at the plain words of the statute. And the plain words of the statute is that it uses warrant as a verb. It doesn't say there has to be an express warranty or an implied warranty in writing. If they wanted to use those words, they would have used those words. And it doesn't have the word reliance anywhere in it. That's nowhere in the statute. So the plain reading of the statute merely means that if a manufacturer or seller expressly declares or assures, which is the word warrant means, that the product has a useful safe life of longer than 15 years. Now, it doesn't say you have to say exactly how long, okay? Because then what would happen is if certain manufacturers say, hey, how about 25 years? Well, those manufacturers have an extra 10 years. If they say, hey, how about 20 years? Well, those guys have an extra 5 years. But if manufacturers like Hubble use the word permanent and folks like GVEC actually believe that means forever, well, they wouldn't have any teeth under this statute just because they didn't say exactly how much longer than 15 years. But to be clear, Judge, and we have a bunch of deposition testimony that we've referenced to a T, every single GVC employee that works with these splices every day believes that they have been warranted by the word permanent, that it's for life, and certainly longer than 15 years. Now, another thing that's important is if you look at how the acts end, you will find that Mr. McCleary rests his argument 100% on the Texas Business and Commerce Code, section 2.313, which is, guess what? A claim based on a breach of an express warranty, okay? That is not our claim. And in this statute, which creates the exception for manufacturers making representations or warranting, there is no reference by incorporation anywhere in this statute of section 2.13 of the Texas Business and Commerce Code. In other words, have the legislature really wanted to say, hey guys, in order for this exception to be met, what you need is an express warranty in writing, like we have required under section 2.13, it would have said it. But it didn't say anything about that at all. So what does the plain meaning then say? If I can show you, Your Honor, based on the case law that we've cited and based on the evidence that we've attached, that warranted, which means declared or assured, that the life of this was longer than 15 years, and specifically taking all of that evidence in the light most favorable to Mendus and showing that there's a genuine issue of fact, then the motion for summary judgment must be denied. It's that simple. So let me take you through those exhibits real quick, Your Honor, and I'll be efficient because I have much less evidence than Mr. McCleary. But let me show you Exhibit A. So Exhibit A is a 1993 document from Hubble. And by the way, if it hasn't been made clear to you already, Judge, Hubble was the predecessor, Fargo was the predecessor in interest to Hubble. And there's no dispute that whatever Fargo did by way of making representations or not, Hubble's not saying that wasn't us. So all of these Fargo documents, this is a 1993 document, and for sure, this document was in existence prior to this specific splice being sold. And what's the first thing we see here? Fargo automatic splices give you permanent, fast, safe installations. If you go on further in the exhibit, page 646, here we are again. After both ends have been inserted, pull down onto the splice to set the jaws for permanent installation. In other words, what are these folks at GVEC supposed to think when they read this, do what they're told, and now believe that they have a permanent fix forever, according to their testimony? We go on to Exhibit B. I'm sorry, Exhibit C, Your Honor, pardon me. Exhibit C is another Fargo document. Go all the way to the top. What's the first thing Fargo tells everybody that has this marketing material about their splices? Fargo full tension ACSR splices are the fastest known method known for permanently splicing ACR developing full rated strength of standard ACSR without barring the core wire. Go down to the next page, which is 005. Point 7, the jaws are set after insertion. An additional monetary tension should be applied to the conductor to assure permanent mechanical and electrical joint. Exhibit D, Your Honor. Now, this is an actual Hubble document now. And you'll see in our response that this person, Mr. Diop, was one of the corporate representatives for Hubble. He wrote this document. And if we go to page 653 of now their very own document, So here's 653, Your Honor. And here's what he says on the left. For optimal service, an initial tension of 15% of RBS must be applied onto the splice at install. This momentary tension, if applied adequately, is enough to provide a permanent and efficient electrical connection. You start wondering again why it is that all these GVEC folks believe that this is forever and believe there's nothing they have to do to replace them until they fail. Well, it's because of everything in the documents themselves. Let me skip forward on skip Exhibit E, Your Honor. The brief speaks for itself. Same for Exhibit F, and same for Exhibit G. And all those three, just for background, Your Honor, are all other incidents that Hubble is aware of where splices have failed in a way similar to this one. All of those have splices that are in the market for more than 15 years, 19 years one, I think 17 one, and over 20. So certainly they're aware that folks are using them for more than 15 years. And so then, Your Honor, we just go finally to some of the testimony in our brief. Let me stop screen sharing because you have the brief before you.
Mr. Guerra, were you showing the test reports there?
No.
Because, okay, I didn't see anything on my screen. So you said stop screen sharing. I just wanted to make sure you weren't showing the confidential test reports or the PPI investigation materials. Thank you.
Yes, sir, no problem. I was not. Yes, Your Honor, on page 13 of our brief, Mr. Diop was asked a question. On page 38, line 23 through page 239, line 4. And the question is, assuming the device isn't damaged and assuming that it was installed properly, whatever that means today, okay, the customer should not have to come back and replace the splice, question mark. Answer, yeah, assuming it's installed correctly and all that, yes. So even the corporate rep is talking about this permanency issue and why it is that maybe these folks at GVEC are reasonable in believing that they're there forever. Up above, an excerpt from Exhibit H is from another witness, Patrick Jenkins, on page 44, line 17 through 19. Question, have you ever seen the Fargo splices being described as a temporary solution? Answer, no, not to my knowledge. So we had another piece of the puzzle, Judge. Not only are they telling people expressly in writing and then in training videos that these are permanent solutions, they're not telling them any different. In other words, if there's any doubt about when these should be replaced, how long they should last, these are really temporary versus not, they don't talk about any of that stuff to anybody. Okay, so from the deposition of Mr. Craven, I'm sorry, first from the deposition of Mr. Christmas, page 187, line 14 to 17. Question, and what does the word permanent mean to you? This is me asking Mr. Christmas, Judge. Answer, it's that it's there for life, for the life of the conductor, for the life of the line. Okay, then there's Mr. Craven, page 144, 11 through 14. Question, okay, are there sleeves designed to be a permanent fix? Answer, that's my understanding. That's what it has on their website, that it is a permanent connection. So I think, Your Honor, like I said, the brief is extensive, and I think that we have at least given you the evidence for you to consider. Certainly, if you take all of the evidence given to you by both sides and taking in a light most favorable to Mr. Mendez, we believe that there's no question that there's a genuine issue of fact with regard to whether or not these folks have warranted the verb that these splices have a life longer than 15 years. To the extent that there are red herrings on cases that have held that reliance was a requirement. Again, Your Honor, we believe all of those cases are because they're based on a cause of action for breach of express warranty, which we do not have here. We are not pursuing it. That is not our cause of action. And then finally, Your Honor, the statute speaks for itself. We believe that under the plain meaning of the statute, there was no incorporation of section 2.313 of the Texas Business and Commerce Code. There is no word reliance used in any portion of that statute. And to the extent that it wanted to limit, if it could have, to only breach of warranty claims or only express warranty claims, it didn't have anything of the sort. All it is a requirement that folks like Hubble or Fargo, for that matter, if they're going to represent to the world like GVEC that do work to protect the American public, hey, these are permanent, these are forever. Once you're done, you're done. There has to be consequence to that, Judge. And the consequence can't be that just because other people who don't make those representations get a statute of proposed defense on 15 years, then they simply can't do it. At a very general course, there's for sure a genuine issue of material fact, whether or not that's what they meant. And I think a jury should decide. So for that reason, Your Honor, we ask that their motion be denied.
Your Honor, if I might.
Hey, Mr. McCleary, do you want to take up your evidentiary objections first, or do you want to respond first?
If I might briefly respond, Your Honor.
Go ahead.
If I could share screen here. And I see myself. I don't see necessarily what I have shared, Your Honor. Do you see?
Yeah, that they changed that a few months ago with Zoom. Used to, you could see what you were sharing.
Technology. In any event, hopefully you can see this is actually an excerpt I have up from our reply to plaintiff's response to the summary judgment. Can the court see that?
Yes.
Okay, thank you. Mr. Guerra cited some deposition testimony from Mr. Seydou Diop. Your Honor, Mr. Diop, first of all, had a clarification and correction to his testimony that we referenced in our reply, inserting that that the term permanent, Your Honor, is used in a particular context, and that's in the context of the installation of these splices. And Your Honor, these splices, they've been described as like Chinese fingers. And so when there's a storm, a tree knocks down a wire, they need to get power back up, they can take these splices and put the conductor, the wire, in either end, and it'll hold it together. And the point is, on the GO402 automatic splices, Your Honor, the term permanent, according to Mr. Diop, is in the context of the installation of that splice and not having anything to do later on to complete the installation of that splice. You put in the ends and follow the instructions, and that's the installation. It's as contrary to temporary ground set equipment, which are used by utility companies when they're constructing power lines and doing repairs. They have temporary type equipment that you have to come back and do something to replace that. So that's the context of the term permanent. It's not a temporal, this thing's going to last forever. And it certainly doesn't say a safe, useful life for a specific number of terms, which are the express words of the statute. Furthermore, Your Honor, we cited a case, the Auto House case, 794 Southwest 2nd 459, that if you have terms that are too vague, non-specific, they're imprecise, they can't be relied upon as part of a warranty. And in this case, Mr. Guerra has interpreted the statute. I'll pull that up. Actually, we had, and the court will recall in my PowerPoint, that the original statute prior to 1993, in effect for, let me start over. The statute in effect prior to 1993 referred to representations. The statute as amended and applicable September 2003 for cases filed after 2003, like this one, changed represents to warrants in writing. Mr. Guerra has cited no authority, and I'm aware of no authority that would interpret warrants in this statute to mean what he says, a representation, a declaration, or an assurance. There's simply no authority for that. And instead, the plain meaning of the statute refers to a warranty, a warrants in writing. The plain meaning clearly would refer to a warranty. And again, I emphasize that the statute plainly requires a number of years warranted. There has been nothing argued or offered by the plaintiff to tender a number of years warranted The only number of years for a warranty applying to Fargo is a 1-year limited warranty. And then I would also point out, Your Honor, that again, we do have objections, but the testimony of what GVEC linemen or even representatives believe after the fact is completely irrelevant. If they want it to last forever, well, they may want it to last forever, but that's not evidence of a written warranty extended as to this particular splice for a specific number of years for a safe, useful life. So all of that evidence in that respect has not been demonstrated to be relevant, and it doesn't show the warranty for a specific number of years required under 16.0.012C. Thank you, Your Honor.
Sarah, did you have anything before we start on the objections to the evidence?
Yes, Your Honor, just two brief points. Again, to be clear, Your Honor, there's not a whole lot of, can you stop sharing your screen, Roger, do you mind?
Yes.
I thought I did that.
There.
Go ahead. Okay.
Thank you.
So Judge, again, there's not a whole lot of case law on this statute. I'll be real honest with you. There is only breach of warranty cases. And I think that distinction is important because it is a cause of action for breach of warranty in those cases, a cause of action which we are not asserting. There are no cases that talk about non-breach of warranty causes of action in which, of course, if we're exercising a breach of warranty cause of action, then words like that may be too vague to succeed under that cause of action. That's not what we have here. The question is there a fact issue about whether those words like permanent are a representation or warrant, the verb, that allows Your Honor to find there's a fact issue whether it should be extended. It's that simple. And secondly, Your Honor, with regard to the after the fact, what he's talking about after the fact is after it was sold. Okay, but let me tell you how it is relevant. One of the causes of action we have against GVEC is that they failed to properly maintain the line and the splice. Okay, so one of the reasons they failed to replace these splices on a temporary maintenance scheduling order is because they believe they were permanent, like they testified to under oath, because they believe they were forever. Then it's completely relevant why they did it. And guess what? They're going to defend themselves by saying that's what Hubble told us. So it's completely relevant to the case. And that's all I have, Your Honor.
Okay. And I'm looking, do I have a copy of the Hubble's objections to the evidence? Is that separate from your?
Yes, Your Honor, that's a separate document. And see if that was. I believe, yeah, that was sent in the first email in a Citrix file.
Okay, I've only received the one Citrix file that made it through. There's only one made it through to me.
Well, Your Honor, I can send you an email with that specifically right now. I apologize. I don't know why that didn't go through.
Yes, go ahead.
Thank you. All right. That email has been sent, Your Honor.
Okay, I'll wait for Ms. Riley to forward it.
I'm waiting for it to come through, Judge.
I understand.
I just forwarded it to you, Judge.
Thank you. All right, go ahead, sir.
Thank you, Your Honor. Your Honor, Exhibit A to plaintiff's response. First, I'd like to point out that none of these exhibits, even if the court overrules our objections and considers the exhibits to the plaintiff's response, raise a genuine issue. None of them provide evidence of a expressed written warranty with a stated number of years of a safe, useful life provided by Fargo with respect to this splice manufactured in 94 and sold by May of 1997. With that said, in that preface, Exhibit A is a technical bulletin, and we've objected to that on the grounds that it is not relevant. It hasn't been shown to have been a document that was ever provided to or seen by anyone at GVEC prior to GVEC's decision to purchase the splice. So we object on relevance, lack of foundation, lack of predicate.
You want a response with each objection?
Yeah, so let's do them one at a time. I'll never remember otherwise.
So Mr. McCleary's entire objection based on relevance, Your Honor, it requires that an element be reliance. Again, we've already, by way of our argument, reliance is not a part of the statute. It is only a part of a breach of express warranty cause of action, which we have not asserted here. Therefore, it's relevant to the extent they made the representation, and the representation showed a life of more than 15 years.
No evidence this was ever in the possession of or provided to GVEC in the record, Your Honor.
And again, Your Honor, that would only matter if it's a reliance issue. The statute only requires that they make the representation. The statute doesn't require reliance by GVEC or anybody.
Of course, we disagree on that, Your Honor.
All right, and Exhibit B?
Exhibit B, we don't object to Exhibit B other than to the extent the plaintiff is relying on, other than the specific excerpts that they refer to in their response, Your Honor. And I don't think they are. They haven't argued it. They haven't included anything in the response. So otherwise, we don't object to the specific excerpts included in Exhibit B.
I agree with Mr. McCleary, Your Honor.
Okay, Exhibit C?
Exhibit C is a Hubble produced document. Once again, like Exhibit A, Your Honor, we object that there's been no evidence demonstrating this document was in the possession of or seen by GVEC in connection with GVEC's decision to purchase the splice at issue. It's not relevant. There's no foundation or predicate for this Exhibit C, Your Honor.
Same response, Your Honor, as Exhibit A. Reliance or having been seen by certainly Mr. Mendez or GVEC is not a requirement of the statute. All that's required is an express representation, which we have here.
All right, Mr. Guerin, I'm just thinking out loud, which is always dangerous. Is it the plaintiff's position that for a cause of action on something like strict liability, that basically the manufacturer makes an election. By that, I mean, if they don't ever say in writing that their product is good for more than 15 years, then they get the full benefit of the statute of repose. But that if they ever do state in writing that it's good for more than 15 years, then they've waived the benefit of the statute, at least through the period of time, if there's a specific period of time they've said it's good for, and that you don't have to prove knowledge or reliance, just that they've made an election in effect, and that in this case, Frago elected to state that their products were good for permanently.
So slight difference, Your Honor. So the answer is going to be yes, but it's really depending on who. Okay, so think of how this splice was sold. This splice was sold to GVEC by Fargo, and whatever representations were made in writing to GVEC or not, or whether they read them or not, that's a GVEC issue. But then many years later, that product, after being installed, failed and severely harmed Mr. Mendez. Okay, so the reason that it is not required that anybody rely upon it is because, first of all, there's no proof that GVEC ever even saw a warranty or reliance upon anything, but it's intended to protect third-party plaintiffs that have no business or understanding of what the deal was between party one and party two. Okay, so let me put it differently. Car cases. Okay, say Takata is going to put an airbag in a Ford automobile. Okay, and Takata tells Ford, hey, as long as your car is moving with gas, this airbag is going to be good for life. Okay, but if you read the statutes like Mr. McCleary reads it, then 20 years down the road, if that airbag fails, even though they made that representation for life, and a plaintiff who has no idea what they said to each other is the one that's harmed, he doesn't get the benefit of the statute. So if there was a breach of warranty or express warranty claim by GVEC against Hubble or against Fargo, then I think a lot of Mr. McCleary's arguments would make sense because they have to have relied upon what they told them. But here we have an innocent third party, Mr. Mendez, okay, who by virtue of actions of GVEC in believing this was a permanent fix and ever maintaining the line, got severely burned. Okay, but the reason he can't ever rely upon these representations is because he never sees them. Okay, he's not even in that business. So by definition, the statute itself has to protect other people that never have a chance to rely upon what was said by anybody. So let me wrap up what I believe your question was. I believe that if a product manufacturer makes a representation that a judge or a jury believes says, hey, it's older than 15 years, whatever that is, then what happens is if they get sued specifically for breach of warranty, that cause of action still requires a reliance element. And they get to say, show me reliance, okay? But if they don't get sued for breach of warranty, which is why the top part of the statute shows all of these different causes of action, and the cause of action for which they were sued does not require reliance, in this case, failure to warn, then they don't get the benefit of reliance. It's not a part of anything. It's only a question that they make the representation, and does the case now get the benefit of the doubt that the statute of repose is extended for whatever they said. They chose the word permanent. They could have used another word. They could have said permanent, but for only 5 more years. They could have said permanent, but in no case longer than 15 years. They didn't. They used the word permanent. It's their words. Those words come from their file cabinets. And to the extent we've given you evidence of before 1993, before this was ever sold, that's what they're telling the world. Whether this specific person saw it or not is irrelevant under the statute.
Your Honor, if I might briefly respond.
Yes, sir.
Mr. Guerra has given a good jury speech. I would suggest it's just not supported by the law. It doesn't matter what the plaintiff's causes of action are, as long as they're product liability claims, which is undisputed. Plaintiff's claims in this case are product liability claims. They don't need to assert a breach of warranty claim. But when a case is subject to a defense here of the statute of repose under section 16.012B, plaintiff does have to show, per the language of the statute, that the manufacturer, seller, Fargo, expressly warrants in writing, that's the language of the statute, and then, of course, as the court has seen, the number of years warranted, specifically a number of years. So Mr. Guerra doesn't offer any authority in support of his interpretation of the statute, number one. And number two, the motion doesn't even depend on whether the plaintiffs have to demonstrate reliance as proof of warranty. I believe they do. I believe that without that, there can be no warranty. There is no evidence of an express warranty as contemplated by 16.02C. But it doesn't even matter because even the evidence they rely upon does not include evidence of a stated number, a number of years warranted. None, gone, doesn't exist. So all this argument about permanence, it's interesting from an academic standpoint, but it doesn't impact the merits of Hubbell's motion in this case because there's zero evidence that we warranted a number of years other than the evidence we offered that the only warranty we would have extended, if any, we Fargo, would have been the 1 year limited warranty, not one more than 15 years. Thank you, Your Honor.
I just make one quick statement on that point, Your Honor.
Yes, sir.
So I don't know where Mr. McCleary is getting these words, okay? What it says is if a manufacturer or seller expressly warrants in writing that the product has a useful, safe life of longer than 15 years. It doesn't say it has to say for how long. It doesn't say it has to have a number. Okay, so the reason there's a fact issue in this case is either the jury is going to believe that the word permanent means much longer than 15 years, like every single GVC employee testified to under oath, or they're not. But it's a fact issue. That's the whole point. And secondly, Your Honor, the reason that there is no cases that I've cited you is because every case, the three that were cited to you by Mr. McCleary are all breach of warranty cases. That's the law we have. And so we can't use the cases in which breach of warranty, express warranty, as a cause of action and the fact that there was no reliance on those cases as any authority in this case, because that's not a cause of action in this case. So call it an issue of first impression or call it an issue of reading the statute. Maybe the reason that there is no case law is because the statute says what it says. If you use a word that some people believe is longer than 15 years, then it's longer than 15 years. They use the word permanent.
Your Honor, may I make one quick response to that?
Yes.
And share screen. Your Honor, can you see the statute up on the screen?
Yes.
Okay. Mr. Guerra just read part of the exception under 16.012C. He read the first part. He didn't read the rest of it. And the court has seen it. Quote, if a manufacturer or seller expressly warrants in writing that the product has a useful, safe life of longer than 15 years, a claimant must commence a product's liability action against that manufacturer or seller of the product before the end of the number of years warranted after the date of the sale of the product by that seller, end quote. That is the express, clear language of the statute that applies, Your Honor. So it's not just they have to warrant for something more than 15 years. The statute requires you warrant for a number of years of longer than 15 years before the sale of the product. Thank you, Your Honor.
So it's up to the jury to figure out how many years permanent means, Judge. If they'd use the word for life, that means that we don't get the benefit of the statute just because they use the words for life or permanent versus the number of years. That cannot be what the statute means. That if you use a word instead of a specific number, but by definition, that word means what everyone in the world knows it means, permanent means forever, that they don't get, that somehow the statute doesn't apply to them. That cannot be the law in Texas.
Okay, your next objection?
Okay. I believe that takes us to Exhibit D, Your Honor, which Exhibit D is it's been referred to as a white paper authored by Mr. Seydou Diop. And Your Honor, the evidence, if you look at that exhibit on page, let me see here. On page HUB 000660, the last page, I believe, of that exhibit, it identifies it as a copyrighted 2018 document. There's no evidence that document was available or written prior to 2018. It's not relevant. There's no demonstration or evidence that it's relevant, and there's no evidence establishing the foundation or predicate to its admissibility.
All right, Mr. Guerra?
Again, Your Honor, that's only evidence of what they're telling the American public. If you see the trend here, Your Honor, the reason that's important is because they haven't changed their tune. Okay, the very first Fargo document, are as far back as we can find, way before this was sold, uses the word permanent. And the only point is that Hubble has continued to use it to this day to include by their corporate rep, to include the training videos they have on their website, which all has to do with our negligent maintenance claim. If the folks at GVEC keep hearing the same story, keep hearing the word permanent, keep believing that this is for life, then why would they go maintain the line? They just wait for it to fail and people like Mr. Mendes get burned up.
Okay, Exhibit E.
Exhibit E is Exhibit E, F, and G, Your Honor, are all confidential Hubble investigation reports by Hubble on other matters. They all are dated 2014 and later. They simply have no relevance to a splice sold by Fargo in prior to May of 1997, and plaintiff haven't demonstrated any relevance or any foundation or predicate with respect to exhibits E, F, and G.
So, Your Honor, because they were confidential, we filed all this response under seal. But again, as I told you in my argument, E, F, and G are all internal Hubble documents. All of those documents have failed splices like the one here, and all of those splices are older than 15 years. So to the extent that they occurred before our incident, they certainly knew that folks like GVEC were relying upon their permanent representation and leaving them on there until they fail. That's why E, F, and G are relevant.
Okay, and are they the same sort of, the exact same splice, or?
Yes, Your Honor, exact same splice.
Yes, Your Honor. Well, not these splice, but obviously
Well, yes,
the
but
same catalog number.
The
or
same model.
Splice. Yes, Your Honor.
Okay, all right. And if I'm looking here, is that all of them, or?
No, Exhibit H, Your Honor.
Okay, go ahead.
Exhibit H are the excerpts from a Hubble corporate representative, Patrick Ray Jenkins. Generally, Your Honor, again, we've objected that the plaintiff has failed to demonstrate the relevance of the testimony. There's no foundation or predicate for the testimony with respect to a splice sold by Fargo, not by Hubble, but by Fargo, not later than May of 1997. Your Honor, we also included some specific objections to the specific excerpts based on objections to the question, the form of the question, or we think that, and also we included in our objections clarifications offered by the witness, but I'll only go into detail on the particular excerpts if the court wants me to do so.
Okay, and I'm sorry, what did you say you included in your objections? What?
Oh, there was a clarification by Mr. Jenkins to one of the excerpts that the plaintiff offered. It just clarifies his testimony, although I don't think it has any impact on the summary judgment, Your Honor. I just wanted the record to be clear.
All right, Mr. Guerra?
So first of all, Your Honor, to the extent there are Fargo documents testified to by Hubble employees, it is undisputed that that Fargo became Hubble and Hubble assumed all their liabilities and all their documents for the purposes of this case. That's not an issue. But secondly, all of this testimony is me going through the documents with their corporate representatives about all of the exhibits which I showed you when it comes to the word permanency, starting with the Fargo documents all the way through. So we incorporate all of our same arguments when it comes to relevance, when it comes to what that means, when it comes to the word permanency. It's the same stuff, just now being discussed with the witness by way of testimony.
Okay. All right, and Exhibit I.
Yes, Your Honor. Once again, this is also testimony from a corporate representative of Hubble, the deposition testimony of Mr. Sadhu Diop, and we object to the excerpts offered Once again, the plaintiff has not demonstrated the relevance and provided any foundation or predicate with respect to the relevance and admissibility of this testimony regarding a splice sold by Fargo not later than May of 1997. We also have some specific objections we've offered in our response to the form of the question, and which I can get into if the court would like me to do so. And we also added a clarification that's in the record with our reply that was provided by Mr. Diop that the plaintiffs did not include in their response.
Okay. We can get into the form of the question in a moment. Let me just let Mr. Guerra say, make his general answer.
Same response as exhibit number 8, Your Honor. They're the same argument, same document, same issues.
Okay, and on the objections as to form?
Okay. 238. Let me scroll to that, Your Honor. Excuse me. 23. Okay, the question 238, line 23. Assuming that the device isn't damaged and assuming that it is installed properly, what, for whatever that means, okay, the customer should have to come back and replace the splice? Question mark, objection form. Yes, the question, Your Honor, is vague and ambiguous as to which device they're referring to. Are they referring to some device maybe sold by Hubble in 2020 or 2010? Are they referring, is the question referring to the particular splice sold by Fargo back before May of 1997? It's vague, ambiguous as to what device and what customer they're referring to. Are they referring to GVEC, who had no documents or information about this particular splice? And by the way, I want to correct one thing that Mr. Guerra said. He said Hubble sold the splice or Fargo sold the splice to GVEC. There is no evidence of that in the record, none. But so the point is, the question does not identify what device and what customer they're referring to.
Okay, all right, let me look here. Exhibit J.
Exhibit J are excerpts from Mr. Robert Christmas's deposition. For a lot of the reasons we've talked about, once again, we object these excerpts are not relevant. They haven't been demonstrated to be relevant. They haven't been demonstrated to have any foundation or predicate with respect to a splice sold by Fargo not later than May of 1997. And GVC representatives who admitted they have no idea what documentation they had, if any, and relied upon or reviewed when the decision was made to purchase the splice. We also objected to certain specific excerpts on relevance. And what permanent means to Mr. Christmas in 2021, based on the Hubble video, which was posted online in the mid-2010s, is not relevant. And Your Honor, we attached a copy. If I could share screen very quickly, Your Honor.
Go ahead.
Thank you. Okay, do you see, Your Honor, this YouTube excerpt? Or
no?
No? Okay. Let's see which.
Are you trying to play a YouTube excerpt? I see there's a.
No, Your Honor, it's a document. It's a.
Well, yes, I see there's a YouTube.
Oh, you do?
Link in there or
okay.
Address.
Do you see a document with the heading YouTube, a dark document with the that begins the following video may contain demonstrations?
Nope.
Okay.
All I see is a PDF.
Okay. Do you see it now?
Yes.
Okay. Your Honor, we've attached this to our objections. The transcript they offered of the video that's the subject of the examination is, I believe, on YouTube, was found on YouTube. It does, the transcript, by the way, which is subject to later objections, doesn't include, it's not complete, doesn't include this introductory part of the video. But if the court can see here at the bottom, it's dated April 10, 2015. There's no showing or evidence that the video that plaintiffs have offered a transcript of was available, shown by, seen by GVEC with respect to this splice prior to its being sold by Fargo in May of 1997. So it's not relevant. And we object to this testimony because of relevance and lack of predicate and foundation.
Mr. Guerra?
Your Honor, a couple things. First of all, reliance, to the extent he keeps bringing it up, is not a part of section 16.012 or the plain meaning of the statute, and I think we've established that. Secondly, the GVEC employees deposed, both Mr. Christmas and Mr. Craven, have been there since 1994. Both of them said they've seen this video, which is 2015. Mr. Mendes' accident occurred in 2017, which meant to the extent that these folks saw a video that told them these splices were permanent forever, and they did nothing to maintain them or change them out. Raj, would you mind stop sharing your screen?
Oh, yeah, excuse me, thank you.
The fact that they may have seen it in 2015, 2 years before this accident, understood the word to mean permanent, to mean forever, and not changed it out, that's relevance. But to the extent we have a motion for summary judgment here, Judge, where the issue is there a genuine issue of material fact, what the word permanent means, and whether in fact that means what it needs to mean under the statute, certainly what people that use and read that word every day, Mr. Craven and Mr. Christmas believes the word permanent means, goes to that issue. And it means forever. So the question, the genuine issue of material fact that Your Honor has to figure out whether there is or not to go to the jury, the fact that these gentlemen read those words, watch the training videos 2 years before it is that Mr. Mendes got hurt, and what that means to them is completely relevant to whether there's a fact issue, certainly when you take the evidence in the light most favorable to Mr. Mendes.
And Mr. Guerra, let me ask you, are you alleging that Hubble has an ongoing duty to warn or duty to clarify?
Well, no, other than to the extent they keep putting stuff up that's new that people are relying upon, then yeah, I mean, if there is a misimpression being created by the word permanent ever since the 1993 document by Fargo, and then adopted all the way to the white paper by their corporate representative to even include training videos on their website, and they realize and they figure out somehow through these other incidents that these splices are failing in the exact same manner, but that they're older than 15 years, it's up to the jury to figure out what they need to do. What we're claiming from a legal cause of action is that they should have warned. They should have either taught GVEC how to properly install the splice by not over-tensioning it, and what they should have told them is when you use the proper splice with the right conductor, both of which are issues in this cases. That's the cause of action. But to the extent we're talking about should the 15-year statute of repose apply or not apply, the issue is solely what they're telling the world and what they've continued to tell the world since at least 1993 to this day. And what that word means by way of do we have a fact issue or not is what Mr. Christmas says and what Mr. Craven means, the folks that see those videos and get trained upon. That's what I'm saying.
Your Honor, the record is that the splice was manufactured and sold by Fargo, not Hubble. Doesn't matter what Hubble said, thought, or believed after the fact. It's irrelevant. And it doesn't matter what Mr. Christmas or Mr. Alvarez believe permanent means, unless they demonstrate that it relates to or that it's a part of an express warranty in writing for a specific number of years, which we don't have any evidence of.
Except that Hubble said the exact same thing that its predecessor company Fargo said in the exact same way. So of course it's relevant. They've assumed liabilities for that company.
All right. Is there an objection on K? Yes.
On K, yes, Your Honor, that's testimony of Sean Alvarez, the corporate representative of GVEC, and it's the same objections and same issues with respect to Mr. Christmas in general. And once again, the testimony concerning what Mr. Alvarez thinks or believes and is not relevant. And certainly there's been no demonstration that it's relevant or that there's a foundation or predicate with respect to a splice sold by Fargo not later than May of 1997, as to which GVC had no documents or records that they can point to that they reviewed or relied upon.
Same responses to Mr. Christmas and Mr. Craven, Your Honor.
Okay. L,
Your Honor, we object to L, the testimony of Todd Craven, another GVEC corporate representative, on the same grounds as we've discussed with respect to J and K. I can go into more detail if the court would like.
it's all right. Mr. Guerra?
In response, Your Honor.
All right. M,
M is the last one, Your Honor, and that's a purported transcript of a video. It's a Hubble video, not a Fargo video. I showed the court the YouTube page that was omitted from the purported transcript. It's the transcript we object on the grounds of lack of authenticity, lack of relevance. It doesn't include the full video, and the video is it's dated on YouTube 2018, as I recall. There's nothing showing that it's relevant to a splice sold by Fargo prior to May of 1997. No foundation or predicate.
Mr. Guerra?
So first of all, Your Honor, we agree that the portion Mr. McCleary says was omitted should be included. It should be. Secondly, to the extent that Hubble has assumed all liabilities for Fargo representations and kept the representations the same, that being permanent, the video, which was 2 years before Mr. Mendez had his electrocution, is relevant to the extent that there are continued representations of permanency, which folks like Mr. Craven, folks like Mr. Christmas, and all the folks at GVEC believe the word means forever, which creates a fact issue for the purposes of this motion for summary judgment.
That's it, Your
Right,
Honor.
sir. So, Mr. Guerra, on some issues or the duty to warn issue, you believe that there is a reliance component?
No, Your Honor. There is no reliance component in any cause of action that we have pled against Hubble. We've only pled strict liability and negligence, neither of which have a reliance requirement.
So then what is the relevance of the ongoing
So the relevance of the ongoing, again,
representations?
two things. One is when it comes to this story that was what Fargo said before this was sold in 1993, the word permanent, it's to show, Your Honor, that number one, Hubble has adopted legally all the liabilities for Fargo, but has continued the use of the same word. In other words, they can't say that was a Fargo thing, not ours. That's number one. But the second part is that it's relevant to our causes of action against GVEC. One of our causes of action against GVEC is you guys did nothing by way of inspecting these lines, trying to determine which splices are about to fail, and having a regular maintained replacement program so that you don't wait until they fail, hurt somebody, and then replace it. So if the GVEC guys are saying that there's a video prior to Mr. Mendez being hurt, and that video says this was permanent in nature, and they believe permanent meant forever, then that has relevance to do with their failure to maintain claim.
Your Honor, that Hubble may have used the word permanent has no relevance to the summary judgment and the grounds for the summary judgment or under the statute, for the statute of repose.
Except that there's a fact issue where that means it's an express representation that it's more than 15 years. That's what we've been fighting about for the last hour.
Statute doesn't refer to representations, it refers to warrants and warranty.
All right, I will take this under advisement and look at your documents in the cases. Anything else this this morning?
Your Honor,
This
just
is
for the
still morning.
record,
Oh.
obviously, we're asking for a ruling on Hubble's objections. I understand you're
Yes,
taking those objections under advisement and ruling later. Is that correct?
yes, sir.
Thank you, Your Honor.
And Judge Wilson, I have 3 orders in e-file on this case. Do you want me just to print them out and present them to you?
No, I just clicked on my e-file and I was able to get into it. I have 2 laptops going here, my county laptop or state laptop that is running incredibly slowly. But I was able going one thing at a time. I couldn't.
One of them was returned unserved on a Marisol.
Right.
Castaneda.
So go ahead and post them into my judge's queue and let's see if I can't reach them there. And what are the 3
Will do.
orders?
Go ahead.
What are the 3 orders, counsel?
There should be an order granting Hubble's summary judgment motion and an order granting Hubble's objections to plaintiff's exhibits to the reply or response, I should say.
And the third order, Your Honor, is an order denying the motion for summary judgment. And to the extent we had an objection to the declaration, that's why I asked you to make a ruling on the record. So those 3 orders are all you need: granting, denying, and then Mr. McCleary's objections to each exhibit.
Okay. All right. It sounds good. We'll excuse you and we'll take a check on our family case and then get going on that before too long. Mr. Guerra, are you kin to Henry Guerra? He used to be a radio newsman in San Antonio.
You know, Judge, I used to be asked that question a lot, and I'd always say no because I'm not. But now I just say yes because it always makes me more famous.
Oh, okay, okay. He was. Yeah, he was. I remember as a little kid listening to him on the radio, and I guess he passed away 20 years ago or something like that. All right. Okay. Let me ask you. You were excused, and I see Mr. Pedroza is still here, or Ms. Pedroza. Mr. Reina, where do we stand on the family law case from Atascosa County?
Yeah,
Honor,
hi, Judge.
thank you for your time, Your Honor.
Yes, sir.
Thank you,
Hi,
Judge.
Judge. John Dist here. We're going to need a hearing, Judge. I think it's going to be about an hour.
Okay. All right, we're going to take a brief break. Let me ask who all, Mr. Reina, that is your client, Mr. Disru?
Yeah, he's my client, Your Honor, and I believe Ms. Pedrosa is self-represented.
Okay, and it looks like everybody else has taken off. All right, so I was trying to figure out who the other folks were. All right, again, I'm having computer issues, Mr. Disru. If you would send me or post in chat, if you can, copies of whatever the live pleadings are. This
Yes,
is a
Your Honor.
motion to enforce, I believe.
Yes, Judge, there's a motion for enforcement. There's also a new petition because the parties have 2 children and the existing court order is only regarding the older child, and then request for temporary orders.
Okay, let's see. Well, let's come back at 12:20 and we will start then.
Okay, thank you, Judge.
Mr. Disrood?
Mr. Disrood,
Good afternoon, Judge.
good afternoon. I don't know if you posted the documents to me in chat, but I got kicked out of Zoom before I was able to get them downloaded.
I just, let me ask my paralegal. I think that she downloaded them in the chat. Do you want us to send it to you directly? Email?
Just no, I got kicked off of Zoom, and I signed back on my other computer, which is working at the moment. But the easiest way is chat, as long as my computer's working. If not,
Okay.
I'll get back to my other one.
Okay, let me check with her. Okay, Judge, hopefully you have it now.
Yes, I'm trying to open them up. Let me. All right, go ahead, sir.
Yes, Judge?
Go ahead. I've got them all.
Okay.
Ask, what all witnesses do you expect you're going to have? Just your client? And
My client, Your Honor, just, he'll be my only witness, and then I think Ms. Pedrosa is representing herself.
all right, Ms. Pedrosa, I'm asking you to unmute yourself. All right, and can you hear me, ma'am? All right, Ms. Pedrosa? Ms. Pedrosa? All right, I am not able to hear you. I don't know how fast your internet connection is.
I apologize. Can you hear me?
Yes.
Okay, let me get back on the video. Okay. I don't know how fast the connection might be.
All right, and let me ask you also to move where you're sitting and or the camera, because it's difficult to see. You're silhouetted against outside light, it looks like.
Yes. I'm actually in my room.
That's fine. I just want to be able to, everyone can see you. Okay, as long as you're not silhouetted with the light right behind you, that's fine. All right,
Okay.
so Mr. Reina and Ms. Pedrosa to raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor. Yes, Your Honor.
All right, Mr. Reina, I could just barely hear you, so if you'll speak up.
Yes, Your Honor.
All right, go ahead, Mr. Disrood.
Yes, Judge, if I can just frame this case for you. The parties have two children, a boy, Fabian Jr., he's 5 years old, and he's the subject of the original suit that was a court order was signed March 28th of 2016, and that's the one we're seeking to enforce. And then a little girl, Amor, was born August 18th of 2018. And so we filed a original petition regarding her, so that we could establish paternity. And then the issues today are enforcement of the original order. We're alleging that respondent has not allowed my client to have visitation with the children since May of last year. And so we're asking the court's assistance in enforcing the order.
All right, and Ms. Pedrosa, and I'm sorry, I was looking down writing. Are you still there?
Yes, I am. I just have to keep moving my phone so I can hear you guys.
Okay, and what are you hoping to do today?
I am hoping to have my kids see their dad and get the visitations right. I am not hoping to go back to the same orders that were there in 2016. I'm trying to get a new order, new dates with new visitation rights for both the kids, and also come to an agreement to where Fabian Reina, the dad, can pay a weekly, monthly, whatever is possible to prove that he is going to move forward and be there as the father for my kids. That way he can have his visitations rights how he should.
All right, ma'am. I need to ask, have you filed any paperwork to have what's on file in the previous case changed?
Yes, sir. I went in to Atascosa General Office in Jordanton last year around, I want to say it was July or June of 2019 or 2020. And I never received a call. I never knew anything about that. So I just stayed until last Thursday when I received the papers from Fabian Reina's attorney or lawyer that I had this
All right,
court date for
so let me rephrase this, ma'am. Have you filed any official documents with the district clerk's office asking to have the previous orders changed?
Yes, I have.
All right, and does Mr. Disrood have a copy of those?
Does who? I'm sorry.
The attorney for Fabian Reina.
Oh, I am not sure. I don't know if he has a copy of them.
Do you have a copy
I just
of
know
them?
Dist?
Okay, do you have a copy of them?
No, I don't. If I do, they're at my house, and I'm not at my house right now. I'm at my mom's.
Okay, Mr. Disroot, are you aware of any of any motions to modify or for temporary orders that have been filed by Ms. Pedrosa?
No, Your Honor.
Okay. All right, and Ms. Pedrosa, I need to tell you a couple of things. One, are you asking for criminal contempt, Mr. Disroot?
Yes, Your Honor.
One, Mr. Disroot is asking for criminal contempt.
And what does that mean?
Well, that means that he's stating that you have not followed the visitation orders. And he's asking that I find that you have not done so and that you did so. Basically, you could have followed the orders and you just chose not to. All right. The example I'll give you is if you are and the children or Fabian Jr. are on vacation in Corpus Christi and your car breaks down and you don't make it back in time to turn him over to his father, and that's just a one-time thing, that's a good excuse. Okay. And you wouldn't be held in criminal contempt. If you're held in criminal contempt, then you could be punished by being fined or by being placed in jail for up to 6 months. The other thing I need to tell you is that the obligation to pay child support and the obligation to turn the child over for periods of possession or visitation are completely unrelated. I've never actually done it myself, but something that I had happen when I was in Mr. Disroot's shoes is that my predecessor, Judge Stella Saxon, she said that I was right and I represented the mother and that the child support hadn't been paid and that the father was right. He hadn't gotten his visitation, and because it has come up before, she held both of them in contempt. And she said, whoever's doesn't have the kids because the other parent has the kid or the child that weekend, that parent's going to be in jail for the next month or so for serving out a jail sentence. So now that you know that whether Mr. Reina has paid his child support or not is not relevant at all to visitation and whether he's gotten his possession, because even if he hasn't paid his child support and he could have, all that means is that you would have the right to file a motion to have him held in contempt and to have him put in jail. Would you like an opportunity to speak to Mr. Disroot? Let me finish my question, man. Would you like an opportunity to speak to Mr. Disroot in a breakout room and see if you can come to any agreement about something this afternoon, or do you want to just go ahead with the hearing?
We can try to come to an agreement this afternoon. And speaking on the 2016 case, we did go through and I was allowing for my son, Fabian Jr., to see his dad.
And ma'am, I'm going to tell you right now, I'm going to instruct you not to say anything else right now. And we'll get into, if we need to get into the merits, then we'll get into the merits. If y'all are going to come to an agreement, then you'll be able to come to, and I don't need to hear about that right now, and nothing good's going to come from saying it. So I changed the breakout room that you and Mr. Disroot were invited to for the time being. I'm not inviting Mr. Reina. I'll let the two of y'all speak. If you need to have Mr. Reina put in there too, let me know, please, Mr. Disroot.
Yes, Judge.
Okay. And I don't know, have you gone to a breakout room before? Do you know how to follow the link? Ms. Pedrosa?
No. Well, I just got invited. Let me join.
Just to hit accept and you should go off. All right, Mr. Reina, I'm going to keep working on things here on my desk. I'm going to mute you and I'll just wait for them to come back. All right, Ms. Cavazos? Okay, we're back on the record in the matter of the Rainier children. Where do things stand, Mr. Disrood?
Hey, Judge, I think we have an agreement to, first of all, establish the paternity of the little girl and to have establish orders regarding both children as far as the visitation and possession, and to sort of clarify how that's going to work. And I can explain that further, and then I will just choose to not go forward with the motion for enforcement today. I'd like to see how these orders go first, if we can get compliance.
Okay, sir. And I'm going to ask Ms. Pedrosa to unmute her telephone. And do you want to read the agreement that you do have into the record?
Yes, Judge. I think the parties agree that petitioner is in fact the biological father of the little girl or more, and to establish, have the court make a finding to that regard, appoint both parties joint managing conservators, with mother having the right to designate the residents within Atascosa and contiguous counties, that the father would have an extended standard possession order, specifically that he's allowed to pick up the children from school or from their daycare on Thursdays and on Fridays during his possession, and that he's allowed to return the children to school. As I understand it, the little girl, children sometimes are with grandma, and so I'm asking that mom communicate with my client through text message if the children are where he's to pick up the children. Specifically, the little girl, I believe, stays with grandma in Somerset. And so my client will pick up that child from grandma. And that specifically, that it's acceptable for my client to use his sister, Felicia Reyna, as his designated person to pick up and drop off the children.
Okay, all right. And Ms. Pedrosa, and how about child support?
Child support is going to remain whatever he was ordered to pay. I will get with the Attorney General, Your Honor, as far as the child support, because you're right. I didn't think about that. Now that we have another child, that probably needs to be modified.
Yeah, and 2016 was the last time she was on child support.
Okay, I'm not sure I know what that means, but all right. Okay, ma'am, except for child support, is that your agreement?
Yes, we will get an agreement, and he can see the kids. I don't mind. I don't have an issue with that.
He can do
I
what?
agree with what his attorney is saying.
All right, and with child support, on the issue of child support, are you in agreement to leave it for the Attorney General's office?
I'm sorry?
That the two of you, that you're both going to go with the Attorney General's office, and they will they have their whole process where they will go ahead and update Mr. Reyna's income and then tell you what the new amount is for two children?
Okay, so we would just go into the office, correct?
Well, I don't know if it's just going to the office. If you go and see the Attorney General's, I think they'll give you a number. That doesn't mean you have to accept it. If both sides are willing to accept the Attorney General's number, then yes, Mr. Disrood could just put that in the final order. And ma'am, something that I should have said that I did not was today is just temporary orders, and temporary orders are just that. They're orders that are in effect until there's some final judgment made sometime in the future.
Okay.
All right, Mr. Disroot, how long would you need to get that typed up?
Your judge, I can get it to you within a week.
All right, so we want to go ahead and set this for an entry date.
Yes,
Say-
Judge, that would be fine. Let's do that.
All right, Ms. Riley?
Would I be able to get a copy of those orders as well?
Yes,
Yes,
ma'am. Let me tell you what's going to happen. Mr. Disroot is going to draft out the orders. He's going to send that to you. And again, it's just temporary orders. And if you agree that that's what you've agreed to, if you would sign them, that would be good. If not, hopefully you and Mr. Disroot can work that out. And if you cannot work that out, then Ms. Riley at the Court Administrator's Office is going to give us a date that we'll have to be back, and we'll have a hearing on just whether or not the written document Mr. Disroot has prepared is what y'all have agreed to.
Okay.
Sometime in the future, we're going to have a hearing on final orders that's either hopefully agreed to, if not contested.
Yes,
So
ma'am.
Judge, April 1, you have those 3 cases that were for entry of order that were reset from, I think, the 18th or the 16th. You want to just add it to that docket? I'm sure
All
Mr.
right, is that
Disroot
too
would.
soon, sir?
What time would that be, Judge?
I mean, the docket starts at 9. You don't,
Otherwise, the 5th, April 5th is available for you. That's an Atascosa County docket, and you're here in, that's a Monday.
Yeah, I'm pretty packed on April 5th. I mean, I have something in Bear County on the 1st, but I mean, I'm sure I could bounce back and forth on.
yes, sir, you don't have to be here right at
Okay,
9 o'clock. I mean, I'll be on for some time, I'm sure.
okay, all right, that'll be
Let
perfect.
the
then.
coordinator know with an email or something where you are, so that, you know, we know you're not just blowing us off.
Yes, I'll do that. Can I have Ms. Pedrosa's email?
Yes, my email is flor96ped@gmail.com.
Okay, so that is FLOR, which is your name, 96ped@gmail.com.
Yes,
Okay, I'll send you a copy of the order, ma'am.
thank you so much. I appreciate that.
Okay, and we set that for the 5th, I think it was?
The first, Judge?
The first for entry, I'm sorry.
And that's going to be on
so
both.
April 1st?
Yes, ma'am. And again, Ms. Disroot, Ms. Pedrosa, if you are in agreement with the document you're sent, you don't need to be here. No one needs to be here. Mr. Disroot will just file that with the court electronically, and I'll sign off on it electronically. If you have a disagreement about whether or not the document he has produced is what your agreement is, then you need to be back in court on the 1st.
Okay, so if I agree and signed, I don't need to be there, just my lawyer, but what if I don't have a lawyer or attorney?
Ma'am, there won't be anybody here. If you're both in agreement,
Okay.
Mr. Disroot will just send that to me through the computer system, and no one will be here. I'll sign off on it.
Okay, thank you.
All right, is that everything?
Yes, sir, thank you.
Okay, then I think we're finished with court. Everyone is excused. We'll
Hey,
have
Judge, I
a-
have a question before
Oh, yes, ma'am.
completely sign off. On the case, those tax cases, all of them are having a judgment granted, except for, I heard something about the cases with Mike Finkel.
Yes, I mean, that's assuming, again, I've been pleasantly surprised and pleased that I was able to actually use Zoom. Later this afternoon, I'm going to be off Zoom and using just logging into Atascosa County. So if I'm able to log into Atascosa County and see things, then I'll be able to get that finished.
Okay. All right. I just want to know how I'm going to close out my cases. So that's good. Thank you.
But you'll get a copy of whatever I am given. You'll get a copy of it
Okay.
because it'll be in the judge's queue.
Yes, sir.
And go
All
ahead
right,
and
Judge.
take stuff there. I was able to get it cleaned out.
Okay. And I apologize. I wasn't able to get you that list of the cases for Finkel with the ad items for those tax cases. there's not like a program. I asked Chris with the district clerk, see if she could help me with that, but I'm not sure she's been able to obtain that.
Okay, that's fine. We'll just weed them out as it goes along.
Yes, sir.
Yeah, no.
All right.
Anything else?
I think that's it, Judge. I think that's
Okay,
everything. I
I
believe.
will see y'all soon.